All rise. The Honorables, the presiding Chief Judge and Judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning and welcome to your North Carolina Court of Appeals. My name is Chris Dill and I'll be presiding today. To my right is Judge Hampson and to my left is Judge Wood. We thank Catherine Bryant, who is our clerk today, and to Officer Salou, who is our marshal today. We have, 13 cases on the calendar today, but consolidated for argument. It's Funderburk and the rest of them versus Continental Tire, and we will hear from the appellant, and let us know if you want to reserve some time for rebuttal.
I do, but before we begin, Your Honor, these were 13 cases consolidated, and I know the court had talked about previously how we were going to argue this. I don't know if we're doing just a straight 30 minutes for the whole thing, because I have some general arguments and then some things about each individual case. I don't know if we're going to be limited to the 30, and if we are, that's fine. It would be helpful if I had more time, but I'll do whatever the court wishes.
Do y'all want to be heard on that, or I mean, did y'all talk about this, or?
I don't plan on taking 30 minutes unless the court has a lot of questions. But
Well, if we have a. Yeah, we'll give you 35 minutes. We'll give you 35 minutes if that's all right.
I appreciate
And
it.
if we are firing away questions, I mean, I'm not a total stickler about the clock if we're asking questions at the end. So, how much time would you like to save for rebuttal?
I'll take 5 minutes for rebuttal.
Okay, we'll see how it goes, because I know it's just a little unusual with all these cases. So we want to make sure everybody gets a chance to be heard here. So, okay.
Thank you. May it please the court, Ed Polly here on behalf of the 13 plaintiffs. I don't want to go deep into the facts of the case, because it goes back over, now we're talking 14 years. So I will briefly state just a couple of things that I think are important for your consideration today. 14 years ago, or approximately 14 years, I've lost count at this point, there was a lot of cases filed against Continental Tire. These included asbestos cases, occupational asthma, cancer cases, hearing loss cases. And the commission decided to consolidate a group of the asbestos cases for primary purposes that we could take depositions ahead of the hearing, which is usually not allowed in workers' comp. And we could use that information for all the cases so that we wouldn't have to redepose the same people time and time and time again. It started going on longer than we had anticipated, and I had asked that a first group called the Bellwether cases were put together. It was originally 6, but for the most part it became 5. Those were to be tried, and in the middle of the trials, I had asked that we start an additional 5 cases, and the judge had the hearing in September of 2011 saying, we need to come up with a plan on how we're going to continue doing this. And eventually it was ordered that what we would do is complete the Bellwether cases, go through the appeals that would enable the parties to better understand the positions regarding some of the more salient issues of the cases. So at that point, the judge said we were going to then have mediations of the remaining cases, and then any that don't get settled.
Well, at this outside, so much understand. So when you had the Bellwether and y'all had this agreement to do it that way, did y'all have any understanding that the evidence that was offered to the Bellwether could just be used in the other cases, or that you'd be bound by any findings? Or what's your understanding of what was agreed to as how the Bellwether case would be binding on the other cases?
Our understanding, and the transcript, which is attached in the record of appeal, shows what the judge goes through this and says that if we take a deposition of a person who was head of IH, that deposition could just be used in all the cases without the need to recall that individual. All the evidence would then be admissible in all the cases. There was no indication that it would be binding, that it's winner takes all.
The finding would be binding, any finding made based on that evidence.
And the reason we know that is because the judge said, we're going to try these first ones, we're going to let this go through the appeals, then we'll mediate. Well, if the appeals were going to decide the cases, there'd be no reason to mediate any cases. He also then says in the transcript from that.
Which judge? When was this?
This was Deputy Commissioner Geen. It was actually started with another Deputy Commissioner, but he just kind of oversaw it. Then it became Geen that was trying the cases, and then eventually was, after Geen retired, it became Gillen's case.
Let me ask you a quick question.
Sure.
So it seems as though, looking at the transcript, what the judge described was the same way in which federal courts address Bellwether claims. Really to see which way the wind is blowing for these particular cases to help the plaintiffs or the defendants decide whether or not to settle the case. So it seems as though that's what he was describing in the transcript itself. But are you aware of any other holdings within the state that are contrary to what the judge described?
I am not. I know for a fact that there's cases dealing with collateral estoppel, where the Goins case that I cited in my brief, which was a gentleman was injured, he tried his case, and then during the appeals, he passed away. His wife took over as executor, and then the case was decided. Then she filed a death claim, and the defendant said, wait a minute, collateral estoppel on the issues from the first claim, and this court said, no, they're two separate claims. And so I know that's not exactly what you're talking about, although I agree with you on this is how it's handled in MDL litigation, and that in big group class actions is, and this is what the judge said. The judge said, then we can try the remaining cases in an abbreviated fashion. Those are his words, not mine. And he said we can then bring in evidence just about that individual, whether that be exposure evidence, medical evidence. We won't need to retry it with all these people in terms of all the evidence, all the witnesses, but we can restrict it to just what's relevant to this individual. And that's what was understood, and that was in that hearing and became that order. Now, we know that's what the commission thought, because when this case made its way to the Court of Appeals eventually said, you know, this applies to everybody. But that was the first time it had been mentioned outside of defense. And then when I filed the defendants filed the motions to dismiss in these 13, we went before the deputy commissioner. And I said, and they claimed there was an order that said this is all binding on everybody. Now, if that was the case, that was the time for this to be decided and this to be brought forward. And I said, I'll give up all my time if you'll just show me the order so I know what I'm arguing against. And there was no order. It went to the full commission. They made the same argument. There's an order. I said, there is no order. If you've got an order, show me. And then the commission decided, they didn't decide that it was an order or this was the procedure. That's not what the full commission said here. The full commission said, this is collateral estoppel, and you didn't appeal the full commission for these 13 who were not part of the case. So the notion that somehow there was a scheme or design to make all these cases binding, that's just not accurate. And it's not reflected by the commission. It's not reflected by any orders of Deputy Commissioner Game. So we then filed, after the cases made their way through appeals, we then went back and we were going to proceed with the remaining cases, and defendants did the motions to dismiss. They went before the Deputy Commissioner, who for some cases found that the dismissal was inappropriate, and some that she did dismiss. We appealed that to the full commission, and then they dismissed all of them, and that's where I am here today. The first argument I made, and I'm going to make today, is the commission said it was collateral estoppel. And as I've briefed and as the court knows, collateral estoppel, in order for collateral estoppel to apply, it must be identical issues in the case. It must be necessary for the judgment, those issues, and the parties must be either the same or parties in privity. And it fails on all three because it's not the identical issues. These individuals, these 13, have jobs that were unlike any of the 5 bellwether cases. So their exposures would have been much different. They have diseases that are different. There are mesotheliomas, as the court may know, is a horrible lung cancer that causes death, and it's caused only by asbestos. None of the bellwether had that. As I said, some of the guys were electricians. None of the bellwether were electricians. Some of the guys were millmen. None of the bellwether were millmen. So there's a lot of differences in the cases.
So then, what is your contention that the bellwether cases actually did? What was the point of the bellwether part of these cases? What did that establish?
Sure.
From your standpoint.
Again, the purpose of the bellwether, as evidenced by the judge's order and the transcript, was to allow the parties to present all the evidence that they have specific to those individuals, but also some plant-wide stuff in terms of IH information, where asbestos was located in the facility, the fact that they had an asbestos management team, things like that were introduced, and how the workers would work with asbestos around the pipes.
And so the Court of Appeals, this court in Hinson, seems to take a two-part approach to the analysis, sort of the issues of common fact, and whether, in fact, there was, the type of asbestos, the exposure, the nature of the exposure within the plant, sort of the plant-related piece. And then separately, you would move to the individual determination. But the court seems to rest its decision pretty heavily on that first piece, that of, you know, the form of the asbestos, the quantity, that piece, before kind of moving into the more individualized pieces, such as, you know, the frequency, those sorts of things. So how do you address that piece of the Court of Appeals opinion in Hinson that focuses more on those generalized concepts and says based on this, you know, the Hinson and the other claims fail?
Well, it wasn't for the court to make the decision of whether these facts allow or were sufficient for all the plaintiffs. That wasn't the case, and these 13 were not, the court didn't have jurisdiction over these 13 cases. They weren't on appeal. And so the court in the Court of Appeals, they were talking about the facts that we had presented. And I acknowledge it was a broad base, but it wasn't specific to all these individuals. There was no evidence specific to Mr. Huffstetler. There was no evidence submitted that was specific to electricians. There was no evidence about the tire building area. And so there's a lot of these factors in these cases. Matter of fact, 3 of the cases weren't even part of the consolidated group. And I repeat that. 3 of these cases weren't even part of the consolidated group. They were filed after these cases had already been tried, and the commission dismissed those as well. So these weren't specific to the individual. That's why the judge in the case said what we're going to do is present all this global testimony that we can use in all the cases, but then if we can't settle them later, then we'll go to each individual case and have an abbreviated hearing where you can present evidence specific to that individual about how he was exposed and about his disease, because the court had talked about asbestosis, and a lot of these aren't asbestosis cases.
But did the commission in Hinson say that did they find that the level of asbestos could not have caused asbestosis in anybody? Did they find that?
Essentially, that's correct. It wasn't sufficient to cause asbestosis. But again, we weren't allowed to present evidence, because I asked to present evidence on these cases to demonstrate how they were different from the bellwether, and that was denied at the commissioner level. So I've never been allowed to show why these cases are different, how they differ from the finding that there was insufficient exposure. You can't say that there was insufficient exposure for any part of the plant. That's the end of the story. And one of the reasons I say that is because of a case I cited, Austin versus General Tire. A worker from the same plant we tried years ago, and he worked with asbestos. He got asbestos disease. We tried the case. It was found that Austin had an asbestos-related disease. The defendant, Continental Tire, General Tire, it's the same company. They paid the claim because it was appealed, and we won all the appeals. Now, if they decided in that Austin case there was sufficient exposure, and now we have a case they say there's not, it seems a little bit arbitrary for the commission now to say, well, these 13, there can't be because of those cases. Well, what about the Austin case? Could I have just said, well, we won Austin, so any case, every person in that facility now is exposed to sufficient amounts of asbestos to cause disease? That would be a stupid argument. I would never make that argument because it doesn't make sense. And it doesn't make sense to me that somebody who works, so if this commission is looking at the 5 bellwether cases, they can then say, well, that means nobody in this entire facility ever was exposed to any amount above this. Well, how do you know that? Because we've just presented evidence about the bellwether. We did not present evidence for these 13 individuals who did much different jobs and were different areas of the plant than the 5 bellwether cases. So I think it strains logic to take those findings and stretch it to anybody else. But beyond that, the Court of Appeals was not there to decide all the cases.
But if I were to say that the commission decided in the Hinson case, no matter where you were in the factory, nobody would have been exposed to any greater danger of asbestos than a member of the general public would be normally, so therefore it can't be an occupational disease. I mean, you would say that's not what the commission found? Or?
I would say that's an interpretation that you can make from that decision, but I think also I think what they're saying is, I think what we're trying to say is that for the bellwether cases. Now, if that's the decision, and it's kind of interesting, an interesting point here, the whole situation with these gentlemen who were filed after, they weren't part of the consolidated group. And to justify this, the commission said, well, we're going to find that this applies to them because Ed Polly is representing them, and this applies to them or anybody in the future.
Just so I have that straight, which ones were not part of the original, that part of the consolidated?
It would have been
Gilbert, Huffstetler, maybe, and
yes, and I'm sorry, I'd have to.
that's fine.
During
Don't
the break.
worry, we'll figure it out.
But so that's really the problem I see there is, so what that holding, if you uphold that, then any client that ever comes to me, let's say today, or I go back to my office today, a gentleman comes in and says, I have lung cancer, I worked at Continental Tire. Well, the way the commission decided, and if you uphold that, then I have to tell that guy, well, no, it says in the order that any of my future clients, they can never have any asbestos disease, and your case has already been decided. Well, that's ridiculous. That's a due process violation if we tell future clients that they can't try their case because it's already been tried by these 5 individuals. I don't get that. The other thing the commission said, and it should worry everybody, they said in the decision that it's okay, even if we don't consider that, we took care to protect their due process rights. That's in the decision, that the full commission said that we don't need to worry, plaintiff doesn't need to worry about their due process. We took care of that for them. And that's frightening. And that's not in accordance with what due process is.
Is the full commission, and I didn't practice workers' comp, is the full commission bound by the findings of the deputy commission
No.
supported by evidence, or do they hear everything de novo?
It's de novo. They can decide they can ignore all the findings, or they can create their own, doesn't matter. It is de novo.
And so the full commission here, at least in Henson, said that they agreed with whatever the deputy commissioner held and said that it was.
Essentially, yes.
But has the lung cancer aspect ever been litigated at all?
No, definitely not in these 5, but I'm unaware of any lung cancer being litigated.
So that issue's still open. Did any of these plaintiffs have lung cancer?
Most of them.
Okay.
And mesothelioma, there's a couple of those. And that's not been litigated. As a matter of fact, their expert said, I don't think there's enough exposure. Their expert's Dr.
So asbestosis was the only thing that was litigated in the Henson case?
There was a colon cancer, and there was a laryngeal cancer.
Okay.
Now, the colon cancer is interesting because there's been a lot of studies that have come about in recent years.
There was no finding in Henson regarding lung cancer or mesothelioma?
No,
never any finding?
There was not.
Okay.
So the other thing, what I was finishing up on collateral estoppel is the issues are not identical, as I mentioned, and it wasn't necessary to the judgment. The Court of Appeals didn't need to decide all the cases when it was just deciding, because the only issue on appeal before them was the bellwether cases, not all the cases, including these 13.
So if the full commission in Henson had said, yes, this did cause all this bad stuff, they wouldn't be bound to that, or would they be?
If the commission had said in Henson that there was sufficient exposure and that all these individuals had sufficient exposure to cause the disease, I would not in good faith bring a motion to dismiss or for finding a summary judgment in our favor on all future cases, all cases ever. I don't think that's appropriate under the law. Because
Well, that's also not how bellwether cases work either, is it? It's just kind of a forecast.
Right, exactly. And the reason I say that is because you can't say that each individual in that plant has the exact same exposure. You have gentlemen who are standing by a machine all day and there might be a pipe above their head. You have other gentlemen who are pipe fitters who are taking asbestos insulation and ripping it off and taking hammers and beating it and grinding it up and taking air hoses and blowing it. Now, do we honestly believe that the gentleman who worked a couple feet from a pipe has the same exposure to the pipe fitter who's beating it off a pipe? Absolutely not. You have to look at each individual to determine their case because that's the way it is. There's also a thing I don't want to get too deep into the weeds, but there's a thing called a decrease in distance. The further away you get from a source, the less exposure you're going to have. If somebody is sitting in the back of the room disturbing asbestos, I might get exposure, but your exposure will be a little bit less. And so somebody who's sitting right over it is going to have a higher exposure. My point being that you can't just say everybody had the same exposure. That would be impossible. That doesn't make sense, and that's defied, just does not comport to the facts in this case.
Except that the commission, you said you could read the commission's order as saying that no matter where you were in the factory, that level just wasn't enough to give you more exposure than a member of the general public.
And I think that's where the I think.
But you'd say even if they held that, y'all weren't bound by that because you weren't.
No, we weren't bound by it because we weren't. These 13 cases weren't part of that. These 13 cases weren't decided, and like I said, it wasn't within the jurisdiction of the Court of Appeals anyway because these parties weren't before the court. In that case, they've not had a chance to present their day. They haven't had their day in court. They haven't had a chance to present their specific evidence. The Court of Appeals must have jurisdiction before they can render a decision in somebody's case. I know in this case, counsel filed a motion to dismiss my appeal because we had neglected to, on our notice, we had neglected to put to the Court of Appeals. And you guys ruled that there was not an error because it wasn't jurisdictional. If it's a jurisdictional error, you could dismiss my appeal. Well, obviously, if the court doesn't have jurisdiction, then they can't act upon an appeal. My clients, the court never had jurisdiction over these 13 people because they never were appealed. There was never a notice to these 13. They were never included. I looked, I got your calendar. All 13 cases were on there. The cases in the bellwether, there was only 5 cases listed. Not all 100 or however many, and these people weren't included. I want to go real quick, if I can. Well, as a matter of fact, one other thing before I leave that topic. When the 5 bellwether cases were appealed to the Court of Appeals, the parties filed a joint motion to consolidate those cases. And in that, it's in the record, page 42, we submit this joint motion to consolidate the 5 cases for appeal. That's the specific wording in the record on appeal.
That's in Henson.
That's the Henson case. So obviously the intent was to deal with just those 5. And obviously that language and what happened means the court did not have jurisdiction to hear the other 13 cases, or any of the cases. There were a lot more, but the 13 that we're here to talk about today. I did want to talk as quickly as I can about some of these cases. Marion Funderburk, he died from lung cancer in 2006. The claim was filed in 2014. So his claim was filed 3 years after the consolidation order. His claim was filed after most of the litigation in the bellwether cases. So I'm not sure how he can be bound. His wife can be bound by evidence and decisions made before the case was ever filed. So also, and this goes again, and I wanted to read to you because I think it's important. And I know I'm covering the same ground.
But the findings weren't made until 15, is that right? Or 16?
I believe it was
when one of them retired and the other.
Yeah, that was
there was a consent
16.
order entered, and
but the commission further held, in this case, the interest of the bellwether plaintiffs were
so Funderburk was part of the consent order, I was saying.
The consent order to allow, no, the consent order only involved the 5. You're talking about the consent order to allow this to be heard by Gillen?
Yeah.
Yeah, they have sort of misconstrued that, and I'm not
suggesting what it means. I'm just saying, wasn't that everybody that was in the case, they all agreed to that consent order?
Yeah, what the consent order was that there was a case that came down, the Bentley case, which said that if you start a case before a deputy commissioner and that deputy commissioner leaves, you have to start anew with a new deputy commissioner. And we didn't want to start anew because we had gone through years of litigation. So we agreed to allow him to make a decision in the bellwether cases. Now, it wasn't for all cases because If it is, then where are those decisions? Because none of those decisions for anybody but the 5 bellwether cases were entered by Deputy Commissioner Gillen. So the whole purpose of that consent order was to allow Deputy Commissioner Gillen to move forward with deciding the bellwether cases, because that's when he came in. We had already started preparing the final briefs and final arguments, and he was allowed to make the decision without retrying the whole case. It was not.
Is there a statute that requires somebody the other deputy commissioner to try the whole case, or was that just a decision of our court?
Decision of the courts.
Okay.
I think they based it upon a statute. It may have been 9485, I believe. I think that was it, but
you say you can agree to ignore the statute and do it this way.
We agreed to waive any rights. As a matter of fact, the wording of it, we would waive any appellate rights to that issue about whether we would have to restart if it went on appeal. And I didn't raise that, obviously. And I wanted to read in the Funderburk case something I'd said earlier. The bellwether plaintiffs and their counsel were fully aware they were acting on behalf of defendant Continental employees, including all those represented or to be represented by Wallace and Grant. Now, they're telling what I was thinking, and second of all, they're saying to be represented, so in the future, which doesn't make a whole lot of sense to me. However, even if the bellwether plaintiffs were not aware that they were represented, the interests of other former Continental employees, the court, quotes, took care to protect the interest of the non-party. And that's just, I think, just a really poor statement of law. So also the common interest, I'd like to say there was no common interest between Mr. Funderburk and anyone else, although he did work at the facility and was exposed to asbestos. Mr. Funderburk was a pipe fitter and a welder. None of the bellwether claimants were pipe fitters or welders. Pipe fitters and welders are generally expected to have the highest exposure you can have to asbestos. I don't want you to look for that in the record because it's not there. That's what I'm telling you because I've never been able to present that evidence in front of the commission. It's not an asbestosis case, it's a lung cancer case.
What do you say to they cite, the Cont'l Tire cites on page 17 of the brief, of course, the very purpose of a bellwether procedure, which I think is more of a federal, I'm not sure, was to establish law that would be binding on the parties in non-bellwether cases. And then they cite a bunch of cases. Why is this case different?
I've never seen a case, as Judge Wood correctly pointed out, a lot of these class actions and a lot of the MDLs where we have asbestos or other types of litigation. For instance, I'll give you a good example is because of the Camp Lejeune cases. Those are all going to be consolidated or are consolidated, but they're presenting evidence and doing common testimony, but ultimately it'll be decided and tried on each individual case. I've never heard of a case, a consolidated group, where, all right, we're going to try a group and then it just binds everybody. Maybe it has been. I've never heard it and never done it. And certainly if that had been the case here, we would have needed an order. The commission would have had to order and say, we're trying all these and everybody's bound. If the commission did that and said, we're all bound, here's the order, it's bounding on everybody, I wouldn't be here today. But there is no order. They've said there's an order, and I've asked on 2 or 3 occasions to see it, but there's no order. But the bigger point here is the commission never said there was an order saying that. The commission never said that. The commission didn't decide in this case, in these 13 cases, they didn't say, we made an order saying it's binding on you. They didn't.
So does the word bellwether in this context have a specific legal meaning, or is it just a...
Exactly what I had alluded to earlier, that it was done so that we wouldn't have to redo depositions. We wouldn't have to bring people in to testify 130 times. For instance, these 13 cases, I may have an expert. I don't want to depose that expert 13 times. We would depose them once and then let it apply to everybody. Now, specific information specific to the individual, we would try that like we did with the bellwether cases.
But wouldn't you have asked this expert about the exposure that these 13 have in the bellwether cases? If you're not going to depose them again, because you need to show that these people had different exposures and the asbestos caused it. So were they asked questions about the pipe fitter or whatever?
No. No.
So how do you get that in for your new case if you've already deposed this witness?
Because what we were going to do is the judge said we would try the bellwether cases, get the common testimony and the testimony specific to those people, and then we will have those cases go through appeal. Once it's decided, we'll do a mediation. Any cases can't be decided, we will try these in an abbreviated fashion where we will allow the parties to introduce evidence specific to that individual. We never presented evidence. We didn't go through Marion Funderburk.
Which would include maybe calling that expert up saying, now this particular person did this. Would your conclusion have been?
Right. As an example, we had medical experts testify. They had a medical expert, a doctor down in, Dr. Spangenthal down in Charlotte. He testified. He didn't testify about every one of these cases. He testified about 5 cases. Ironically, he said they were all exposed to sufficient amounts to cause disease. That was ignored, but that's neither here nor there. But that expert of theirs was deposed. They didn't ask him about Marion Funderburk. They didn't ask him about Carl Drive. They didn't ask him about any of these 13 people. I didn't ask about any of these 13 people. It was specific to those 5 bellwether claimants. And so we weren't presenting evidence specific to all these people. And a lot of these we couldn't because, like, for instance, Mr. Funderburk passed away.
Mind you, coming up on your 5 minutes.
Okay. Mr. Funderburk passed away before, or after the consolidation order and after most of the evidence had been introduced anyway. So it had been impossible for us to present evidence about his ailment. Thank you.
Thank you. You'll have 5 minutes for a vote. You can take 35 minutes if you need it.
Thank you. May it please the court. My name is Kip Nelson here on behalf of the appellees. And we have counsel for Duke and Liberty Mutual here as well. But unless the court has specific questions, I'm planning to speak on behalf of all of the appellees. Your Honors, this case is really about trying to take a second bite in an apple. And the law does not allow that approach. That is why the commission appropriately dismissed these remaining plaintiffs' claims. I think it's important to take a step back and look at what actually happened here. In a typical workers' compensation case, the claimant has to show first an injury. When it comes to illness, would have to show a compensable occupational disease. And then, and only then, would have to show where it came from, what caused it. Right? Because if you develop the injury or the illness outside of work, then it's not compensable. Workers' compensation provides compensation for injury or illness arising out of the employment relationship. So that would be how the typical process goes. Here, of course, we had more than 150 claims filed, all based on the same theory, that these workers had been exposed to asbestos at this plant in Charlotte in such an amount that they developed asbestos-related diseases as a result. Given that that issue was common to all of the claims, the commission decided to flip the approach. Instead of starting with, do you individually have a disease, is it compensable, they started with the issue that was common to everyone who had asserted a claim. Was there enough asbestos in this plant that could have caused an asbestos-related disease? That was the question that was tried in the first part, Judge Hanson.
Irrespective of where in the plant you were working.
That is correct. And as Judge Hampson noted earlier, there were kind of two aspects to this. One was there enough stuff in the plant that could have led to something? And the second was, for the individual bellwether plaintiffs, did they have sufficient exposure? Did they have diseases that could be compensable? But the first part was the part that was common to all of the plaintiffs. That's how the deputy commissioner described them. That's how the full commission described them. That's how this court described them. The question answered in that trial was there sufficient exposure to asbestos that could have caused an asbestos-related disease? The deputy commissioner said no. The full commission said no. This court said no. At that point, the plaintiffs could have asked for reconsideration or filed a PDR, but they didn't.
But, thinking about standards of review and standards of review in workers' compensation cases, it wasn't that this court said no. This court simply determined, was there evidence to support the findings of fact, and do those findings of fact support the commission's conclusions of law?
That is correct. The holding of this court in Hinson was to affirm the full commission's order.
And specifically, the analysis in Hinson went through what, did the commission ultimately the full commission, appropriately consider certain factors, including the form of the asbestos, the quantity of the asbestos, the last injurious exposure. And then, and so you've got that piece, and then you have this was based on pathology and, what was in the contents of the individual plaintiff's lungs. So how are those not individualized determinations, at least at some level, as you weigh the factors in determining the nature of the exposure?
So I do agree, Judge Hampson, there are two issues. One is, could anyone develop an asbestos-related disease? Two was, did you individually develop it? As to the first, that's why there was a full trial on the science. That's how it was described. Both sides put up experts, put up all the evidence they could on that issue. The experts disagreed, and the deputy commissioner and the full commission agreed with the defendant's experts. That issue did not depend on individualized circumstances. And we know that because the evidence was not limited to the 5 bellwether plaintiffs. For example, Your Honor brought up the pathology results, which everyone agreed was the best evidence of whether there could be sufficient exposure. But the pathology was not about the bellwether plaintiffs, right? The pathology was on others as well. Even Hinton, who was one of the bellwether plaintiffs and was at least argued at that point to have been the most exposed, they looked at the pathology and said, there are no asbestos bodies here. That should tell us something. That was one piece of evidence that went into the ultimate determination that there was just not sufficient asbestos exposure at this plant. If I could read, on page 25 of the slip opinion in Hinton, this court said, we are asked to review the commission's determinations that conditions at the factory could not have exposed consolidated plaintiffs, meaning which this court defined as all of the plaintiffs, to airborne asbestos of a type and in sufficient amounts to cause asbestosis or other asbestos-related diseases. So I would frankly disagree with my friend's argument that the court's decision was limited to asbestosis, because it wasn't. Throughout the opinion, it referenced asbestosis and other asbestos-related diseases. But that was what this court was assigned to do: review the commission's determinations of whether conditions at the factory could have exposed these plaintiffs, all of the plaintiffs, to airborne asbestos of a type and in sufficient amounts to cause an asbestos-related disease.
So, and assume we buy all that, and that's fine. What in the record binds these other parties to that determination?
Several things. One was the consent order. So we've heard there's no order. Continental has never shown an order.
In the consent order, did it say we'll be bound? I mean, I know there's something that we can, this will be the, I know there's a consent order regarding that the evidence could be used in all cases or whatever. What in the consent order did these parties say we'll be bound by any decision in the bellwether cases?
So this is a lengthy consent order, right? It's several pages long. It's not. I would disagree with the characterization that it was solely to decide who could decide.
No, I'm not saying that. I just want to where in there. So where in it is there?
So this is in the record supplement, page 1. It starts with this order consented to by counsel for all parties, and it lists IC file numbers and plaintiffs' names attached as Exhibit 1, including all of the plaintiffs, and says a couple of things, if I could point out, Chief Judge Dillon. One, that the exposure trial was being held to, quote, litigate the issue of exposure. So not just to take common evidence, but to litigate the issue of exposure.
What paragraph is that? Is that just in the?
That's the
introduction.
The second paragraph on page 1.
Okay.
Litigate the issue of exposure relating to the nature and extent of any asbestos exposure to employee plaintiffs working in the facility. So I think that's one place. The second that I would point, Your Honor, is paragraph 11 of the consent order says, the parties stipulate that all parties have had a full opportunity to be heard on the issues now pending before the commission. So again, they recognize the issue being tried was exposure and have said, we have had a full opportunity to be heard on that issue. And perhaps this is most directly related, Chief Judge Dillon, paragraph 14. By agreeing to this consent order, the parties acknowledge and understand that the stipulations and terms contained herein are binding upon the parties. So I understand the attempt to go back now and change what was put in the consent order, but the language speaks for itself. It said exactly what everyone understood, which was this trial was determined that threshold issue of whether there was sufficient exposure to asbestos.
But the only cases being tried at this time, realistically, were the 5 bellwether cases, right? I mean, that was what was actually before the court, the 5, and wasn't there an attempt later to add more bellwether cases to have another bellwether trial?
The only issues related to those 5 were those individual amounts of exposure and disease, not the issue of was there sufficient asbestos in the plant. That was
To give anybody a disease, yeah.
Correct. So I'm not trying to quibble with your question, Judge Wood, but the bellwether plaintiffs, yes, the evidence related to their individual exposure and their individual disease was limited to them.
And the need for this consent order was the fact that the deputy commissioner who had been trying the case was resigned and was no longer available. And so the purpose was to allow another deputy commissioner to make a ruling. Wasn't that the reason for the consent order? Absent that, there wouldn't have been a consent order, would there have been?
I do believe that was the impetus for the order, Judge Wood, but I don't think that means you can disregard the language consented to by all parties and by the commission. So if it were solely to say, we think Deputy Commissioner Gillen should decide the bellwether plaintiff's cases, then a different order would have been entered. That's not what the parties agreed to. The other reason, though, we know that these additional plaintiffs were included is because the commission included them as an attachment to every order along the way. So in the Hinton record, it looks like the parties use slip sheets, so it's not actually duplicated every time, but there's an Exhibit 1 to every order along the way, and that Exhibit 1 listed all of these plaintiffs. So even though there was a caption at the beginning, kind of as I suspect this court might do with these cases, have a main caption and then say, and here are the other cases that are affected.
So then, if that were the case, and the Henson case goes up on appeal, theoretically, the other parties should be able to appeal it, but that wasn't really the case, right? Because the Court of Appeals made a determination and actually listed the file numbers for Henson and then the other 4 bellwether plaintiffs. So the other plaintiffs weren't allowed to appeal this because they weren't actual parties to the appeal.
I would disagree, Judge Wood. They were parties to the appeal. In fact, Chief Judge McGee said in the opinion, they are appellants. I mean, that was in the opinion.
But their cases weren't up on appeal, right?
Their individual exposure issues were not, but the case as to whether there was sufficient exposure in the plant was on appeal. And this court said, we are treating them as appellants. And I think, Chief Judge McGee, Judge Collins, then Judge Dietz understood the implications of their decision because the opinion is riddled with statements of, we understand this issue might not apply to the bellwether plaintiffs, but we need to address the issue in toto. And this court, a couple of years ago in Appalachian Materials, faced a somewhat similar situation where the first opinion from this court ruled that the trial court or the county had erred in denying a permit. And it went back on remand, and the county said, wait, we should have an opportunity to argue all the other things that we didn't have a chance to present. And this court said, even if our opinion was too sweeping, even if the mandate was too broad, it is the law of the case. That's how our system works. When an appellate court reaches a decision, it is binding on the lower tribunals. Again, in Appalachian Materials, the court said the remedy, if there was an issue, was to file for reconsideration or file a PDR with our Supreme Court if there were some dispute about the legitimacy of the opinion. That wasn't done here.
I would agree with that generally, but if the argument is that if y'all two get an argument about something and I'm not a party and our court says something that affects me, I'm not a party to appeal it. So why would my case be bound by that? I mean, because can't we determine whether or not the Court of Appeals in the prior case even had jurisdiction over these other parties? Because if they didn't, then, do we have to pay attention to that sentence? I guess it's a different argument. I'm not saying that's true, but I'm just...
I do think you have to pay attention. I mean, that's right. Even if there, and courts have said this, even if there was a problem with the opinion, if it's law of the case, it's law of the case. The parties have an opportunity to challenge it and seek review, which nobody did here.
But a court that assumes it has jurisdiction and acts as though it has jurisdiction, that order is void if there really isn't jurisdiction, right?
I believe
Because
it's,
you can't consent to jurisdiction.
I believe it's voidable, Judge Wood, meaning there has to be a judicial determination that it was in fact entered without jurisdiction.
So if we made that determination, that would be binding on you if we said that Henson only had jurisdiction over the 5 bellwether plaintiffs.
And that's why it's important to look at the commission understood, right? So even though the 5 cases were captioned, it included as Exhibit 1 all of the other cases. So it's not as if there was it's not as if there were a stranger to the litigation. I do agree, if this court in Henson said, oh, and by the way, you know, Kip Nelson is also bound by this decision, that would be a problem. If Kip Nelson, right, were a stranger to the proceeding and had no involvement in it. But it's very different if Kip Nelson were listed as a party in the order on appeal, listed as one who had participated in the proceeding, and listed in a consent order to agree to be bound by the determination.
So we keep talking about this consent order, but that consent order was entered subsequent to whatever bellwether plaintiffs was established. Is that right?
I'm not sure if I understand the question, Judge Hanson.
So the bellwether plaintiffs had already been decided. Evidence was presented as it related to the bellwether plaintiffs. Only after that, when Deputy Commissioner Geen was stepping down and the case was being transferred to Deputy Commissioner Gillen, that's when the consent order was entered. Is that correct?
That is true.
So whatever terms of whatever bellwether means in this context, that had already been defined prior to what this subsequent consent order. So
That's true.
Where,
the trial was over.
So where in this and applying this bellwether concept in the record was there any initial agreement that these cases would be binding?
That was, as referenced by my friend, as early as September 2011, when the trial had already started. But at that point, the deputy commissioner recognized that there needed to be a way to handle all these cases together.
Right. And so what our court in Henson says, though, is in addressing the bellwether cases first and presenting evidence applicable to all extant claims, the assumption, that's a great word, was that after the 6 cases proceeded through trial, decision, and appeal, the parties would be in a better position to evaluate the remaining claims. The remaining consolidated cases, in brackets, could then be potentially resolved, or they could proceed to abbreviated hearings for the introduction of evidence regarding their individual medical and employment information.
That's
what the court does not say is that the subsequent plaintiffs would all be bound. In fact, that's not one of the options at all. Like, dismissal is not one of the options listed.
But of course, that was the initial approach in which, right, nothing had been determined yet. So that's exactly right. If the outcome had been the other way, and the determination was, yes, there was enough asbestos in the plant that could have caused asbestos-related diseases, then that's exactly right. Either the parties could have mediated, right, settled based on the bellwether outcomes, or had individual trials on each plaintiff's exposure. So that was definitely an option. Well, the other option is, sorry, if the answer was no, nobody could recover, then I believe, I can't remember the exact language, but could be readily resolved or easily resolved. In other words, there's nothing left to do if we've already answered that question. Sorry.
So the court, that's fine. The court made the commission made a determination based on collateral estoppel. That is what the court made its determination on, and said, you know, these other plaintiffs are bound by the decision that was made in this Bellwether case. But how do you square that with, there was another case, Austin, where there was found to be asbestos and asbestos. How do you, I mean, if we look at it that way, then just because Austin won, that came before Henson, would Austin not then be binding?
So a few things, Judge Wood. First, it's curious to me that opinion is cited because that opinion was reversed by our Supreme Court. So I don't know that opinion could have preclusive effect anyway. But a second thing is that there wasn't a full trial on the science, right? The parties weren't given an opportunity to present whatever they wanted about whether there could have been exposure. But the third is the law carefully distinguishes between offensive collateral estoppel and defensive collateral estoppel. Non-mutual offensive collateral estoppel is highly disfavored, but that's not what we have here. We have mutual defensive collateral estoppel, which does not fall under the same rules. Again, this is a defendant saying, I've already tried my case on whether I could be liable, and I have succeeded. I should be able to stop someone, a party, or someone in privity from relitigating that issue. And it was mutual because Continental would have been bound by a determination just as much as the plaintiffs. Did that answer your question?
Yes, thank you.
So you're saying, so if the commission had determined that there was enough asbestos in there to cause a disease, then when one of these guys wanted to have their hearing, you couldn't have used as a defense there wasn't enough asbestos to cause a disease for anybody because that had already been determined.
We could not have disputed the threshold issue of could someone have been exposed to enough. We could definitely dispute an individual plaintiff's, were you exposed enough individually? Because it's, as Mr. Pauly said, plants had different levels of exposure, right? People had different jobs. So that individualized determination would still need to be made, and I don't think that a defendant in that situation would lose the right to challenge that individualized determination. But the threshold issue of could that even happen?
That was going to be binding on everybody, whatever the decision was. Is what you're saying.
Correct. And I believe that that's clear from the record, that the parties understood it would go one of two ways.
Judge Hampson's question, though, isn't it very different that someone who is working in the office is going to have very different exposure to someone who is working on the pipes and beating down asbestos?
Very much so, which is why, again, the trial was open-ended. The commissioner said, bring in all the evidence you can about the office, about the pipe, about the calendar area, about everywhere. Let's look at what was in this plant anywhere and see if there was sufficient asbestos that could lead to an asbestos.
So they could have ruled there wasn't enough in the office, but there was enough back in the back, because all that was before the commission.
Absolutely.
And so they determined, you're saying they determined there was no asbestos level anywhere in the factory is what they determined.
Yes.
So we don't need to look at the individual plaintiffs to see what they have, okay?
That's exactly right. And I think that's what Chief Judge McGee said in Hinson. I mean, she said, she talked about this inverted approach, that we don't have to look at the individualized things, even though they did eventually get to it in the opinion, but said we don't have to get there because of this threshold issue. That's the threshold issue. Could anyone have developed an asbestos-related disease as a result of exposure to asbestos in this plant?
So go back to something Judge Hampson talked about. Was there anything before the consent order, before the initial hearing, that you could point to in the record where the parties said, yes, we'll be bound by this, any determination on the threshold issue? I know you point to things in the consent order that you say might, and I won't hear the other side address that, but is there anything else in the record? What else in the record would you say where they agreed to be bound by whatever the deputy commission, the full commission, determined on the threshold issue?
So I don't think there's a separate document that says they would be bound. I will say again.
So they never agreed to be bound until they entered the consent order?
Well, no, Chief Judge Dillon, because they agreed, which was evidenced by the commission, including all the file numbers, right? So there was no need for a written order because everyone was operating under the same understanding. This issue only came up after.
That's my understanding. That's my question. What understanding? Was there any evidence of what this understanding is that you talk about?
That all of the cases would be tried on this issue. And if I could point, Your Honor, to the September 2011 hearing, which was admittedly after the evidence had already started, but on page 10 of that transcript, the deputy commissioner says, if the appeals come down and they say, it's a great defense, if the full commission ultimately says, you're right, there's not enough asbestos in that plant to harm a tsetse fly, then, and the Court of Appeals confirms that, what do you negotiate? There's nothing for you to negotiate because this is what you had. So to come back now and say we had no idea that this situation could arise where we would be bound by a Court of Appeals decision is simply not true. The deputy commissioner forecast that issue in September 2011. Again, it wasn't definitive at that point because no determination had been made. If the evidence had come in another way and the determination was that there could have been sufficient exposure, then we wouldn't be here. But certainly the commissioner is representing to all the parties' counsel that this was the way it was going forward. But to answer your question, there was not a specific document recognizing it.
But that statement, you would say, put everybody on notice that, if that's the determination, everybody's bound by it.
Yes, and I'm not aware of any prohibition of agreeing to be bound by something that's already happened, right? A party could agree to be bound by a trial that's still outstanding. I'm not aware of any prohibition against that sort of timing as far as agreeing to or stipulating to something. So the fact that, I guess my position is the fact that it happened in 2016 is irrelevant because.
And it happened before any finding was actually made.
Correct. And Chief, you asked earlier when that was December 2016 that the deputy commissioner decision came out. This was October 2016 when the consent order was entered. So yes, it was before a decision had been made. And again, the parties are recognizing in the consent order, we don't know what's going to happen. No decision's been made. What we are saying is everyone has had a full opportunity to be heard. We've had our chance. We've had our day in court, meaning the commission. We've put on our evidence, and now we're going to let the chips fall where they may. Importantly, as Judge Wood mentioned, the commission focused on collateral estoppel in its decisions, but all four of these reasons are independent basis to affirm the commission's decision. So the fact that there was a stipulation, the parties agreed to be bound, the law of the case doctrine, res judicata, that these claims were or should have been brought earlier and were precluded, or collateral estoppel, each of those is an independent basis to uphold the commission's determination. In other words, plaintiff would have to convince his court that all four of those reasons are wrong. We would suggest that any of those is sufficient and gives the court a basis to affirm.
All right.
Unless there are any other questions, we would ask that this court affirm in all 13 cases.
Thank you so much.
Just to clarify a few things, I'd like to address this whole consent order one last time. I know we've kind of plowed this ground quite a number of times, but as I said earlier, if the deputy commissioner had intended that all these cases would be decided, where are the decisions for anyone other than the five? He only rendered decisions in those five bellwether cases. They're trying to characterize this as, well, parties means everybody, and as Judge Wood, you correctly pointed out, the parties were the five people, and that's what it was restricted to. We know that because he didn't write a decision for anyone but those five individuals. In addition, and I think this is, I'd like to point this out, and I pointed out in my brief, but I think it needs to come up right now. The defendant files motions to dismiss in these cases. How many times did they mention this consent order? 0. In the oral argument for the deputy commissioner on this issue, on the dismissal.
What did they mention then?
They did the first time it was mentioned.
What did they base it on then?
The first time they mentioned it was in their brief here.
I understand. So what did they base their motion to dismiss on?
Their motion to dismiss was based upon the fact that it was collateral estoppel, res judicata, that had been decided by the Court of Appeals, and therefore it was final. They didn't bring this up, and you kind of stole my thunder. I was going to bring it. I was going to mention it every time, but they never brought this up until their brief. So if it was that important, but ultimately, forget all that. Forget everything. Forget they didn't mention it until their brief. Forget they didn't mention it anywhere along the line. The commission never relied on the consent order in their opinion in this case, in these 14 cases, these 13. Not once did they mention the consent order. So they're arguing something that was never in the order. I wanted to talk about real quick. They said they mentioned asbestos-related disease. The evidence presented in this consolidated hearing regarding the fact that this is from the Court of Appeals in Henson, exposures to employees, the criteria for the diagnosis of asbestosis, the scientific evidence regarding asbestos exposure. Here's a separate one. The commission determined employment in the factory did not expose plaintiffs to airborne asbestos of a kind in amounts sufficient to cause or contribute to asbestosis. There was plenary evidence from which the commission could determine the form and asbestos the plaintiff alleged they were exposed to at the factory and was a relevant factor in determining whether plaintiff's alleged asbestos exposure could have caused asbestosis. Therefore, the evidence presented that most of the asbestos was in the factory was chrysotile, and the plaintiffs would have been exposed to huge amounts in order to develop asbestosis. So the Court of Appeals had talked about asbestosis throughout, and it was actually, I will acknowledge that it was kind of confusing the way they went back and forth about it. Counsel said that the Austin case was not tried on the science. And
why did we say that it's not asbestosis or any other lung asbestos disease?
Well, and that's what I'm saying is that, well, I
Well, we
think it's
wrong.
problematic. It was back and forth, so I don't think the Court of Appeals wasn't consistent. But the other thing is that the issues about cancer and mesothelioma were never addressed in the bellwether cases. And their own experts said that there would have been, the exposures could have been sufficient to cause mesothelioma. Counsel said that Austin case was not tried on the science. That's not true. There were experts that testified. There were medical experts testifying in that case. There were experts testifying on exposure. There were disability experts. There were numerous witnesses that talked about the asbestos exposure when Mr. Austin would take asbestos and tear it apart and get exposed to it, that they say doesn't exist now. Counsel said they bring evidence, we were bringing evidence on everything in the office and everything. That's not true. We never presented any evidence on asbestos in the office. We never presented evidence on tire building. We never presented evidence on people that were a millman. We never presented evidence on many of the jobs like electricians. Not one electrician was in the group, in the original group. There was no evidence like that. Counsel also did something else, and this will be the last thing, and I'll sit down. He said that he quoted the deputy commissioner saying, "Nothing to try after we render these decisions. You do not, if there's not enough to hurt a tsetse fly, don't you agree?" He neglected to read the rest of that. And that's when I said, "No, I don't agree, Your Honor, and here's why." And I brought up all the things I've brought up today, that there's different exposures. And he said, "Okay, I get your point." And that's when he talked about how we're going to try the rest of the cases. Counsel took that out of context and ignored the rest of that quote where the judge is talking about how we would try these cases, and that would be that these people would have their day in court, which they have yet to have. Thank you, unless there's other questions.
Thank you for your arguments. We will take it under advisement, and we will return court.
All rise. The North Carolina Court of Appeals is adjourned.